SJC-11506, Commonwealth versus Robert Wade.
All right, let's proceed. Good
Good
morning.
morning. May it please the Court. I'm Janet Pumphrey for Robert Wade. Under Section 7 of Chapter 278A, the Court shall allow forensic testing if 6 prongs are met. The Commonwealth concedes 4 of these 6. The evidence exists. The state police have it. There's no claim of obstruction of justice or delay, and the results would be admissible. The Commonwealth disputes factors 3 and 4. That a reasonably effective attorney would have sought testing, and that the DNA testing has the potential to result in evidence material to identity. The Superior Court denied the 278 motion on 2 grounds. The first denied it on the ground of dismissal without prejudice because of the inadequate affidavit.
Can I just stop you there, Ms.
Sure.
Pumphrey? When Judge Very did that, do you read, how do you read Section 18 as it applies to that decision of Judge Very? Is there a 30-day period in which you need to appeal?
No, Your
or
Honor, the
not?
statute doesn't say that, and it was denied without prejudice.
Well, I
subject
understand
to,
that,
subject
but
to
it does
refiling.
say, it says.
It does say.
It says it's a final order. I think it says it's a final appealable order, does it not?
It does say, except that this was denied without prejudice.
No,
It
but
could
I
have.
thought that it applied to that as well. I mean, it's just
I
like
would
the
suggest that it does not.
statute. Maybe I'm wrong. I gotta get the statute.
I would suggest that it does not. Yeah, that I don't have it in front of me either, but I would suggest that it does not. That when it's dismissed without prejudice, it's subject to refiling, and the issue was the sufficiency of the affidavit, subject to refiling with an affidavit.
So you refiled,
I refiled.
but then you didn't, you refiled in October, I believe?
I refiled.
And then you didn't apply anything at,
No, I refiled a bald motion with both within the motion itself and also within my cover letter to the court, saying this will be supplemented. Please do not mark it for hearing. Please do not rule on it.
right, but that was in October, and the judge didn't rule on it till December. What was there?
It didn't. In the meantime, I was filing. I was trying to get myself court appointed because the statute envisions that, and that was denied also. But that was what was holding, from my point of view, that was what was holding it up. So then it was denied. It was denied, finally denied, and I appealed that. And then I moved for reconsideration. And then it was denied again, and I appealed that also. So, but the second prong is, which I think is the most important thing that you have to consider today, is that the Superior Court also found that DNA testing would not appear to have the potential to produce material evidence. The court's findings were erroneous on both of those prongs. As the basis for that erroneous finding, the court made the wholly erroneous subsidiary finding that there were multiple hypotheses supporting guilt in this case, such as penetration by something other than a penis, and that this was an attempted rape and not a completed rape. That erroneous conclusion is completely at odds with the only theory in this case, which was penile penetration into the victim's vagina, and it was completely at odds with the only evidence at all in this case of a rape, which was the semen. There was absolutely no evidence at all of any penetration other than penile, and there was no theory presented of any such other penetration. And also, there could have been no such evidence because to prove non-penile rape would have required somebody to testify. In this case, there was no testimony because the victim was deceased. There were no witnesses, and there were no incriminating statements. The court also reasoned that this could have been an attempted rape. But like the multiple hypotheses of guilt concept, the attempted rape, that's completely erroneous because if it were attempted rape, it wouldn't have resulted in semen. And semen was the linchpin of the Commonwealth's case here. I would suggest that this subsection, that the requested analysis has the potential to result in evidence material to identification, would always be the case in a case of rape where the DNA evidence is semen itself. By its very nature, DNA evidence is evidence of identification, And you can think of examples of scientific evidence where this would not apply, and I'll give you two examples. One is forensic chemistry testing in an arson case. That would be Chapter 278A, but that would not necessarily result in identification of the perpetrator. And secondly, in a non-rape case, just a regular murder case, a DNA testing of a saliva on a cigarette butt left at a scene would not necessarily lead to the identity of the perpetrator. But semen absolutely, positively will lead to the identity of the perpetrator.
Let's go back to the facts of the case.
Okay.
What are the facts? Where was he found? Naked in his shack with the victim on the bed, naked.
That's right.
Okay, with a broken hip.
That's right. But I would tell you that 278A expressly says, don't consider the strength of the Commonwealth's evidence. You don't consider a confession. You don't consider a plea.
Well, if the question is ID,
The question's identification.
the dude, right?
Not necessarily so. With the amicus brief that was filed by the Innocence Project basically sets out all the cases in Massachusetts with overwhelming evidence of guilt, where DNA testing proved to be exonerating.
What do you say in both 3 and, well, no, it's in 7. What do you say it wasn't filed for purposes of obstruction or delay means in this context? This is post-conviction.
Well, it really, I think the Commonwealth does concede that. It was not filed for purposes of obstruction or delay. And secondly, I've been trying to get this evidence for 10 years. I
understand that,
yeah.
but I mean, I guess my question is, doesn't that language itself suggest something tied with the strength of the case? You don't think so?
I would suggest not. I mean, the entire legislative history of 278A is it's supposed to make it easier for prisoners to get access to evidence. And when you start bringing in the facts of the case, every single one of these cases resulted in a conviction. So every single one of these cases had evidence beyond a reasonable doubt that this person was guilty.
But the defense in this case was not identification.
It wasn't.
And was that defense ineffective under our standards?
I have argued that it was for two reasons. One is that he basically argued a consent theory, and he put forward, and the victim did have Alzheimer's. There was not a lot of testimony at all as to her actual competence. She was dressing herself, she was taking care of herself, she was cooking, she was cleaning, she was sewing, she was doing all these things. She had a little bit of memory loss, was the only testimony as to her incompetence. But of course, the jury was instructed on lack of competence. But he puts forward, the defense attorney continues to put forward this consent theory, and his theory was, and it comes out in the trial, his theory was that elderly women with Alzheimer's have a hypersexuality. So she came to him for sexual intercourse. If he's putting forward the theory of Alzheimer's, then the jury is going to be instructed on lack of consent, and they were. So he basically proved his client's guilt. But most importantly, you have an affidavit from the appellate prosecutor, basically saying that the defense attorney would not sign an affidavit for her, and he certainly wouldn't sign one for me.
Of course he's not going to sign one for the prosecution.
No, but what he is telling her is that he didn't order he had a reason for not ordering the DNA testing, and that was because he was pursuing this consent theory. Well, the DNA testing was not inconsistent with the consent theory. If he had just ordered it, if it was incriminating, it would have been consistent with the consent theory.
But I gather from Ms. Lee's brief that he did argue Bowden in his closing.
He did, and in my reply brief, I've suggested I did look at every single Bowden case that was ever argued, and it's never, ever, ever successful. I found one success, and I'm sure there probably are others, but in the about 80 cases of Bowden being argued, it's not often successful.
But can we say that counsel was ineffective for not asking for it without knowing whether or not counsel didn't ask for it because he thought that the results would not be helpful to his client and that he would be losing a Bowden argument and eliminating all doubt about the source of the semen?
Well, I would suggest it would really be, just a balancing test. When it could have totally proven innocence, it's a much, much, much better.
But if you apply a strategic, there's a strategic reason, can you get around that?
Well, I think you can get around it because it really is consistent with the consent theory, and the Bowden defense is really not much of a defense. It's at all.
Let's say the defense counsel has a conversation with the defendant. Defendant says, "Yeah, I did it, of course." I did it. So counsel is now going to request the DNA test to do what?
Well, in this case, the defendant didn't, I wasn't there, this was a long, long time ago, but the defendant has professed his innocence from day one. He was
Do we know that from his
well,
defense counsel?
We don't know that from his defense counsel, but we do know that from his competency evaluation. He basically said that
I was too drunk. I
I
couldn't
was too drunk,
possibly have
exactly.
had intercourse.
And that's in his affidavit. He was too drunk, and he's told me that, from day one. This didn't happen. And I would suggest that's all the statute says. It says affidavit that states his innocence.
We're
And
trying to figure out whether you've established that counsel was ineffective, which is one of the standards here.
exactly. And I would suggest that he was ineffective. I mean, this.
Because he lost? Because it didn't work? Because it was a very difficult case?
No, but because he should have asked for it. Because if his client is saying, I'm innocent, he should have asked for it.
Do you
When did they know about the other antigen, that there was a third party?
From the beginning. It was testified to.
So the defense counsel knew that there was somebody
That's right.
and didn't pursue that?
And didn't pursue that. Although that was very strangely argued by the prosecutor, which I've actually got some of that. It was strangely argued by the prosecutor. And I asked, this is in her closing, and I asked the chemist, is that consistent with the defendant being the source of the semen on the vaginal swab? And she explained to you it is. Why is that? Because there are numbers, 1 minus, 1 plus, 1 plus, 2 plus. She told you that that indicates 2 people contributed, but only 1 person whose bodily fluids were in that swab could have contributed to the seminal fluid. That evidence suggests the defendant. Well, that's not what it suggests at all. There were 2 people who contributed to the semen. And that's what the serology says, and that's what the chemist testified to. But it was argued very differently in closing.
With respect to the sort of relationship between Section 3 and Section 7, both of which mention the substantively the ineffective assistance of counsel.
Right.
So where is it, in your view, that, if ever, you need to come you, representing the defendant, need to come forward to show that this wasn't ineffective? I mean, that this was ineffective, I apologize. This was ineffective.
it would be here. I mean, it would.
But would it be in the hearing?
Well, I think it would be.
Or would it be in what you need to file with the motion?
Well, certainly Section 3 and Section 7 says both. I mean, it's contained in both, for sure. And I think it has to be in Section 3, and it also has to be in Section 7 as well. And I think.
Enough for Section 3 for you to just say counsel was ineffective for not asking for it, or do you need to do more?
I argued that. And that's actually not the hook that the Superior Court hung its hat on.
No, I understand that.
Yeah.
I'm just trying to figure out.
But it is definitely in both, and I think it needs to be argued at the beginning and argued at the end as well.
To put in some
That's right.
information. You can't just assert
That's right.
counsel was ineffective.
And I argued it.
Okay.
That's
Yeah,
right.
I'm trying to figure out how this case relates to the next case we're going to hear.
Mm-hmm.
The next case relied not on the ineffective assistance prong,
Mm-hmm.
but on the newly developed
Right,
technology.
newly developed DNA testing.
I think theirs was about the same time as yours,
That's
and I
right.
gather there probably is newly developed DNA.
Absolutely.
But you didn't argue that.
Well, I sort of argued it in my reply brief, if you look there, because, I mean, the serology testing that this semen evidence was subjected to is incredibly rudimentary. I mean, the defendant was one of, hundreds of thousands of people, but could not be excluded. And here it's, with contemporary DNA testing, it absolutely would identify who these 2 people are.
Right, but I guess that's, I mean, I gather there was DNA testing available at that
That's right.
time, but
It was brand new.
According to the next case we're going to hear, there was a whole nother degree of accuracy of the more recent tests that were not available in that.
That's exactly right.
Would that matter here? I mean, it's not argued here, but I wonder whether or not the prong of focusing on effective assistance if you put aside that prong and say, well, I don't need that prong, I need to focus now on the fact that there's new DNA technology available now, which was not available then, and I'm going to rest on that prong as opposed to whether that changes the equation here.
I don't think it really changes the equation because there's never been DNA testing here, and there should have been. I mean, I think when 278A was passed, I mean, the fear was that there was going to be this just, floodgates of cases, but there haven't been and there won't be because every case now gets DNA testing, no matter what, and so you're only going to have this little window of cases like Mr. Wade, who didn't have DNA testing then and wants to have it now.
Do you think you had any obligation to identify more than just saying DNA testing? I mean, did you need to specify what one you were looking for?
I don't think so. It would be, obviously the most contemporary one and the most discriminating one. So my time is up, but as I said, I've been trying to obtain DNA testing from Mr. Wade for 10 years. I testified at the Joint Committee before the legislature urging enactment of 278A, and I mean the question I would like to leave you with is why won't they let Mr. Wade have access to potentially exonerating evidence? Thank you.
Thank you.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Plymouth District for the Commonwealth. And it's my understanding that today is the first time this court has interpreted the new statute, Chapter 278A, which came into effect in 2012. And so I might as well start with the policy question that counsel left off with. Why don't you just give it to him, which is the theme of the reply brief and also the theme of the amicus. And I would suggest that that question isn't the right question. That is a question that equates the mandatory pretrial discovery procedures with post-conviction and post-appeal processes. And so we should look at when are we required and when should we give out this type of material for further DNA testing. And the legislature has told us when. I mean, prior to this, we had Rule 30, which told us when, and that was after a prima facie showing, which of course the defendant attempted and lost. His attorney was found to be not ineffective for failing to get DNA testing, and that was done by Judge Walker in 2003, and then the single justice of this court denied the defendant's petition under Chapter 278, Section 33E. So we already have a determination that in this case, that
Yes,
the trial...
but that's taking into account something that this new statute says you don't take into account.
Well, I would suggest, I understand your question, that is, does 278A change the analysis of
Well, to
Rule
the extent that you
30
can't take into account the weight of
confessions
the evidence.
and
or the-
admissions. 278A says the defendant still has to show that it would be potentially exculpatory, which necessarily looks at the facts of the case.
Well, it has to show that it would go to the identity of the perpetrator, right?
Yes. So you would necessarily look at the other evidence in the case. But in addition to that, 278A says the defendant has to make a showing that his attorney was ineffective. If this DNA testing was available, it was. If this evidence was available, it was. If the defendant knew about this evidence, he did. And there was a question earlier by Justice Lank regarding when this antigen was known. And that, my recollection is, that was in March of the year that the trial occurred. So it's 6 months before trial. So the trial occurred in September. In March was when that report came back. And you'll find the report in the defendant's record appendix that explains where the H and A antigens are. Sorry. And that's at defendant's record appendix, page 124, and you see the date of that is March 13th, 1997, so the trial.
But if you know that, doesn't it become relevant then what Justice Gantz was asking? I mean, what's the difference between the technology then and now? And, you could make a different calculus if you think DNA testing is not going to tell you very much or not be particularly accurate or definitive than you would looking, with the benefit of hindsight and, more contemporary technologies that have, in many other instances, shown to be exonerating.
And my understanding is that's the issue in the next case, and the question is that relevant here? Justice Gantz asked earlier. And I would suggest, no, it's not, because there was, at the time of trial, there was a more specific test that was available to counsel. It was admissible. It was admissible 6 years prior to the trial under Kernan, and then Lanigan was 1994, for the purposes of excluding defendants. So if trial counsel wanted a more specific test, he could have gone and got it, but he didn't. So just because there's an even more specific test now doesn't mean that that changes the analysis. He had a more specific test available, and he didn't want it, and there's a good reason why he didn't want it.
What do you think the language in 3 and 7 about for the purpose of obstruction or delay means?
Obviously, because this is the first time you're reviewing the statute, we don't have any case law, which is always my backstop.
I'm looking
What
for
does the judge
your,
think about it? And it's not really something that we have been fighting about in the Superior Court. I would think that the obstruction of justice would be some kind of idea that the defendant is trying to pull a fast one on the Commonwealth. For example, use like a bad expert or something, you know, like a charlatan. I would think it would be something like that. I mean, obstruction of justice is pretty strong language, so.
But what's, to what end? He's already been convicted.
Yeah.
I don't understand
Is this
the
a
delay.
template? Does it come from other jurisdictions, the language where, death penalty?
I don't know. I haven't looked at the statutes in other
Wondered if it
jurisdictions.
has a death
sorry.
penalty component to it.
It just, I'm not contending that the defendant is trying to cause any delay here, and I'm not contending.
And you don't read that as some reference to the strength of the other evidence. That's out of the picture as far as you are concerned.
I haven't looked at it that way because, and of course, this court could interpret it that way, but that goes to the potentially exculpatory nature, which is part of it anyway. So I wouldn't necessarily interpret it as being something that's redundant with the statute. But while we're talking about the statutory construction, I think it's important to note the difference between Section 3 and Section 7. My sister is asking this court to order the testing in this case. And it is the Commonwealth's contention that that remedy is not available because there has never been an evidentiary hearing.
And do you
in this
think
case.
Section 7 has to be an evidentiary hearing?
I think it does.
Because it doesn't say that. It just says a hearing, and I just didn't, I didn't know.
I believe in Section 6A, it talks about an evidentiary hearing. So the court shall order a hearing on the motion if the motion meets the requirements of Section 3. The moving party shall be present for the hearing unless the moving party waives the party's presence at the hearing. And
I
then
just
the
didn't
judge-
see any.
It
I
doesn't
didn't-
say
yeah.
evidentiary, but I would suggest that the defendant has the burden of proof by the preponderance of the evidence. And I would suggest if the determination is that trial counsel is effective or ineffective, then we would look to Commonwealth versus Zinser, which kind of brings me back, and that would require an evidentiary hearing. I think you'd need to know what counsel knew when he made those statements. What did the defendant say to him? Is the defendant saying...
That would be a Section 7 hearing. In other
Yes.
words, it wouldn't be appropriate to, if the ground is, it was ineffective of counsel not to ask for this, and there's allegations and some articulation of why in the motion, the Section 3 motion, then we go, then there would have to be a hearing, which there wasn't in this case,
Right.
correct?
Right. And there wasn't because the Superior Court judge and the Commonwealth maintains correctly found that the defendant did not meet his burden in two ways. The Commonwealth maintains that it's in two ways. One, he did not show that his attorney was ineffective. We presented an affidavit. It's my affidavit. I asked counsel. He's a practicing federal prosecutor right now, but I asked him if he would supply the affidavit, and as I noted in my affidavit, he would not do so because of his concerns over his attorney-client privilege with confidentiality of communications. But if you look at what he knew prior to trial, they waited for this evidence to come back. March, it comes back. You'll see in the docket, discovery is then complete, and it gets set for trial assignment. I mean, it's like a day. So that's what they're waiting for. 6 months later, they have trial. So he knows about the A antigen, and he knows about the H antigen. And he doesn't get further delay. He doesn't ask for further testing. And why? Well, the defendant's standing there naked in a room with the naked victim whose hip is broken and her back has injuries consistent with being dragged there. And to this day, we have no idea what the defendant's exculpatory story of that is. But
Well, let me ask you, all right, so that's number one.
Right, so that's his first problem.
Number two, and you go at length about how the defendant hasn't put in enough of factual innocence.
right,
Okay. Section 2 says there needs to be an affidavit.
Yes.
About that, asserts factual innocence of the crime for which the person has been convicted. And Section 3D says the same thing. I just don't see in the statutory scheme where it is that the defendant has to explain away everything that happened in this case, as opposed to saying, I didn't do this.
well, I think you see the difference between the words. You have to determine what factual innocence means and what it doesn't mean. Is factual innocence a mere not guilty plea? Is factual innocence, merely wasn't me? Or does factual innocence, does that word mean something more? And I would suggest if he's a plea of not guilty or a mere denial would be an appropriate term for the legislature to have used when they were, if all they wanted him to say was wasn't me. But in this case, we have the defendant saying, I didn't rape her and I didn't murder her because I was so drunk. And his language says, he uses
Yes.
colloquial terms for he couldn't have an erection. Well, that does not say that he wasn't involved in an attempt. It doesn't say he wasn't the person in the room. It doesn't say any of those
But the
things.
felony murder is proved by rape.
By attempted or completed aggravated rape.
But there was a separate indictment for rape,
And he was
correct?
convicted of
found-
aggravated rape,
Right, he wasn't found attempted rape.
But
he was
that
found-
necessarily would include a finding of an attempt there, necessarily. And the jury were instructed on attempted aggravated rape.
No, but they found him guilty of aggravated rape.
Yes.
So it seems to me that the attempt is kind of out of this.
I would suggest to you it's not. In every crime that you complete, you've started with your attempt. That the jury found more than an attempt does not mean that the attempt wasn't there.
I would suggest that it may make the identity of the perpetrator a live issue,
If
given
he's-
the fact that you have the two different contributors to the semen.
I would suggest that the term factually innocent requires a defendant to say, I am not guilty under any possible theory.
Which means that this person could not do that because he did not remember what occurred.
Right, and that
But so therefore,
backflips us.
all people too drunk or too stoned to remember cannot make a claim of factual innocence?
Well, that backflips us to, is counsel reasonable when he's making this choice? Because he's got a guy who, in all likelihood, is saying, I was so drunk, I don't know, because that's what he told the doctor when he was having his evaluation prior to trial. So, at best, he told his attorney, I don't know, and the attorney stuck with this very inculpatory evidence and a choice, and he makes the choice. And then he proceeds on his closing argument. He has the consent defense. He has the causation defense, with the broken hip causing pneumonia, and he has his Bowden defense.
How did the consent defense come in?
They brought in descriptions of, I believe through the Commonwealth's experts, descriptions of Alzheimer's, patients with Alzheimer's. I would suggest in those circumstances, he made a good choice. And you can, I detailed his closing argument to some extent in my brief, so that you can see that he used this Bowden defense. I don't think it's appropriate to say, I've read all the appellate cases on Bowden, and it's never a success. Bowden's successful at the not guilty stage, so they don't get to the appellate cases. So you don't know how many times Bowden's used. It's used on a daily basis across the Commonwealth, and it's successful in that people get not guilties on it. And here, counsel used that. You don't have that evidence because they don't want you to have that evidence. It's their burden, and they didn't tell you, so you don't know whose stuff is what. And I would suggest to you, just because it's not successful doesn't mean that it's not a valid defense, particularly when the defendant's statements at the scene are, she came to me. And the only other thing he said when found by the victim's son is, I'll leave tomorrow if you want. So I would suggest that we should not ignore the legislative prerequisites.
One thing sticks in my craw, frankly, I guess. you're saying maybe it was attempted rape, even though there was semen found. There was somebody else's something found on her crotch.
Pants, on the pants.
On the crotch of the pants, not the crotch of the pants, I gather.
Yes.
Isn't this the kind of case where, I mean, doesn't the Commonwealth want to know who that other person was? Especially when it's saying maybe it was an attempted rape and there's somebody else's semen that was there?
I would suggest that the evidence on the pants, the defendant could not be excluded from the vaginal sample or the materials on the clothing. But the crotch of the pants, there's this sample that he can be one of the contributors and not the other. And I would suggest, as we all know, I mean, the reason they want to test this evidence now is that that kind of evidence can stay on clothes for a long period of time when it's not washed. And I would ask you to look at the defense attorney's closing argument, and he talks about the condition of the victim and her clothing and how none of that is attributable to the defendant, that he was talking about the conditions she lived in. I would suggest they lived on a pig farm. I'm not trying to say anything that's derogatory towards people who live on farms or in rural areas. But if you look at his closing argument about the condition of those clothes, I would suggest to you that that would be one more thing he would look at and say, that could have been placed there at another time. There's no way to connect that to this particular incident, whereas the defendant is connected to it completely. It's his house, it's his bed, it's his employer, his employer's mother, and he's standing there naked, standing over the naked victim. I would suggest in this case it was perfectly appropriate for trial counsel not to go get that evidence and nail the coffin shot on his client. That's why it was appropriate for the denial of the motion previously that was affirmed by the single justice, which was a final and unappealable order. I'm happy to answer